segment of our week. So I'm addressing to you as students and also as colleagues and guests from Geneva. But in a few seconds, we will shift again, and you will become delegates again, or ladies and gentlemen, and so on, because we are going to host a couple of side events. So imagine this is the Geneva, this is the headquarters of the either the headquarters of the Office of the Commissioner for Human Rights or the Palais des Nations, where the Human Rights Council takes place. And these are two side events, so activities that is carried out in parallel with the sessions of the council, where research institutions or NGOs, etc., present some information, some data, some updates about their work in the field of human rights. And you will have two sets of presentations, actually, and they will introduce themselves briefly before, elaborating their contents. Please, Professor Oberleitner, welcome. And the two sets of presentations last more or less half an hour. So from 5 to 5:30, then there will be a meeting that can be of interest for all of you, because we will have online Laura Dolci, who is the vice chief, I don't know if it is correct, this definition, of the UPR branch. And of course, we will have also Mohamed Kheir, who will, let's say, enter into a dialogue with you, each of you individually, as students or as delegates or as state officers or whatever. You will decide which hat to use. And the idea is to have really an open conversation about the UPR in particular, but in general also about how human rights are carried out by the officers, the Office of the Commissioner for Human Rights staff in Geneva. Then the second side event will start at 6:30 until 7. So half an hour at the beginning, half an hour at the end. Okay, and in between this Q&A answer session with Mohamed and with Laura Dolci. Okay, I stop here. I hope all is fine. Please come in. Yeah, there are one chair. You can share, alternatively. Okay, there is another chair here. The place is available here. Okay, resources are scarce, and that's mine. if you don't mind. Okay, good. So I'm pleased to give the floor to the first presenters that are around. Okay.
Thanks so much. Okay. Excellencies, distinguished delegates, representative of civil society organization, ladies and gentlemen, good evening. I'm glad to open the UPR Implementation Project side event. After a deep analysis of the UPR recommendation produced in the third cycle of the UPR, we decided to focus on Australia. To facilitate the information gathering process, we decided to create two working groups. The first one is going to present the investigation about the grade of implementation from the government perspective, while the second one gather information referring to civil society perspective and work. The analysis is based on document and report, mainly produced by the Law Council, Home Affairs Department, the Australian Red Cross, Australian Human Rights Institute, and Asylum Seeker Resource Centre. Considering this report and official documents, we are going to report the level of implementation of the selected recommendation. A more in-depth analysis suggests us to focus on four main topics: the condition of the offshore centers of detention of Manus and Nauru, the fast-track process, the compatibility of refugee status determination procedures with international standards, focusing on the principle of non-refoulement, and the human trafficking issue. Now, I give the floor to the government spokesperson. Thank you.
Ladies and gentlemen, excellencies, distinguished delegates and civil society representatives, I am honored to appear before you today on behalf of my government to present Australia's advancement after the third cycle of Universal Periodic Review. First of all, Australia would like to insist on its constant engagement to the protection and promotion of fundamental rights of the people. We do not take for granted the responsibility we have toward them, nor will we ever. In this aim, the UPR is an opportunity to reflect on our performance and to assess where progress can be made. We have listened to the 344 recommendations and have decided to accept 177 in its formal response. It is through this political involvement that we can actually change things and ensure a better future for our children. Through the Commonwealth Ombudsman, we have been able to implement a better monitoring system of the daily conditions of the refugees living in immigration detention centres. To do that, we have implemented an independent government agency that is responsible of the monitoring of these conditions. It inspects immigration detention facilities, including offshore centres, to ensure that detainees are treated in accordance with relevant laws and standards. The Ombudsman reviews complaints from detainees regarding their treatment, their living conditions, and access to services. Its findings create constantly new recommendations that allow us to create better policies if need be. This increase in transparency is something we are proud to have achieved. But this transparency does not end there. Indeed, we have extended our system of mandatory reporting service. Ever since the beginning of this month, actually, on the 1st of November 2024, it is mandatory for all early childhood workers to report sexual abuse on children to the Department of Communities Mandatory Reporting Service. The protection of these children is our responsibility, and we will not turn our back on these kids. Moreover, we are working daily on how to make international standards and national obligations meet. To do that, we have implemented the Migration Amendment to ensure that the Migration Act of 1958 does not authorize nor forces an officer to remove a person. That successfully engages Australia's international obligations relating non-refoulement to the country from which they seek protection. We have also checked the national standards in place and have been able to repeal decisions made by the past that do not make sense anymore. Ministerial Direction number 80 required decision maker to process family visa holders sponsored by permanent protection visa holders who arrived by boat as the last processing priority. That is no longer the case. According to our new Ministerial Direction number 102, all families will be entitled to have family visa applications dealt with under the usual processes, regardless of how they travel to Australia. There will be no discrimination in this processing system. To make sure that this system works well, fairly, and fast, the Australian government has been increasing the budget allocated to the institutions in charge. $58 million have been given to the Administrative Appeals Tribunal, to the Federal Circuit, and to the Family Court of Australia to increase the capacity of those bodies that deal with significant protection visa and all the other migration-related caseloads. We have also decided on February 2023 to allocate another $9.4 million to temporary protection visa and safe haven enterprise visa holders with application assistance and legal service providers. Our country has always been engaged towards an equal, fair, and safe future for all. On the 25th of May 2023, we have amended the Modern Slavery Act. It is a powerful tool for combating human trafficking that came into effect on January 1st, 2019. One of the novelties included the establishment of the Anti-Slavery Commissioner as an independent corps working with the government, businesses, and civil society organizations. Ladies and gentlemen, I welcome in advance any contributions to today's discussion. Australia looks forward to continuing our collaborative and constructive engagement with the members and observers of the Council, with the Office of High Commissioner for Human Rights, and the many other stakeholders of our review. Thank you.
Excellencies, distinguished delegates, representative of civil society organization, ladies and gentlemen, we are glad as civil society representative to discuss the previous presentation about Australia's advancements after the third cycle of Universal Periodic Review. As affirmed by the government spokesperson, Australia is currently engaged in the protection and promotion of human rights. Unfortunately, its commitment is not enough to face the current global migration emergency. We took as a legal framework the 1951 Refugee Convention and 1967 Protocol, in which 3 key principles are outlined: non-refoulement, fair and efficient procedures, and the protection of rights. Non-refoulement prohibits the forced return of individuals to a country where they may face persecution, torture, or inhuman treatment. We, as representatives of civil society, recognize the engagement of Australia in international obligation to the non-refoulement principle. However, while Australia formally acknowledged the principle of non-refoulement and integrates it into its migration policy, the implementation of certain procedures, particularly those associated with the detention and offshore processing, has generated debate. This balance between adhering to the international law and enforcing national policies continue to be an area of scrutiny by domestic and international observers. To move on, the cited Ministerial Direction number 102 could be a powerful instrument to make sure the family visa application system works well, fairly, and fast. In general, the Australian government's October 2023 asylum reform were a step in the right direction, with significant investment in the decision-making capacity and a boost in funding for legal representation. Ministerial Direction number 102, however, seek to create a structured and efficient process for prioritizing by resource asylum claims. However, the implementation is hindered by resource constraint, administrative inefficiencies, and tension between political priorities and international standards. These challenges undermines the directive's goal, particularly in relation to fairness and the effectiveness of fast-track process and, in general, to the protection of basic rights. Another relevant topic that emerged from the recommendation is the offshore processing, that for most of the past few decades has been a hallmark of Australian approach to deterring people from seeking asylum by sea. This policy involves forcibly transferring people elsewhere to have their protection claims processed in the territories of a third state, specifically for Australia, Nauru and Manus in Papua New Guinea. The offshore processing entails grave human, legal, and financial risk. Human risks are evident. Asylum Seeker Resource Centre in July 2024 reported how Australia's policy of offshore processing has caused at least 14 deaths and significant physical and mental harm to the thousands of refugees and people seeking asylum subjected to unimaginable cruelty in the detention centre of Nauru and Manus. The policy of offshore processing has proven to be a cruel failure, not only due to the significant cost to operate a detention regime, over $12 billion from July 2012 to June 2024 has been spent, but due to the widely documented cases of medical neglect, sexual violence, suicide attempts, mental and physical abuse, and countless other human rights violations that have occurred offshore. the examination of the offshore condition cannot be granted because of the deliberate secrecy surrounding people's welfare and condition. Transparency is something to continue to work on.
Ladies and gentlemen, I will now talk about the human trafficking issues from the non-state stakeholders' point of view. So human trafficking is a pressing issue in Australia, with various reports referring to many forms of exploitation, forced labor, sexual servitude, forced marriage, and child trafficking. Since the last UPR, the government of Australia has strengthened anti-trafficking procedures, including the revision of the Modern Slavery Act and the proper implementation of the National Action Plan to Combat Modern Slavery 2020-25. However, some NGOs faced some limits in consulting the information resources available from the government and some economic resource limits to comply with the governmental standards. However, larger companies' performance within the larger companies' performance within the Modern Slavery Act fulfillment have failed in many cases. When we address the support systems implemented by the Australia government, we can talk about the Support for Trafficked People program, the Operation Inglenuk, and the Forced Marriage Support Stream. The Support for Trafficked People program is the core of governmental anti-human trafficking strategies, but because all of three were has always been managed by the Australian Federal Police, they sometimes represent a deterrent for the victim to join the support system, and they kind of have a fear of engagement with police forces, which is often rooted in the concern of putting the family at risk. When we then look at the international agreements that Australia did in the context of ASEAN and Australian region, we can see that Australia signed the Australia Counter-Trafficking Program and the Convention Against Trafficking in Persons, Special Women and Children, but the different degrees of commitment by states in implementing the agreements jeopardize the actual realization of the agreement, even if Australia appears to be the main founder of the two of it.
Thank you.
Excellencies, distinguished delegates, and representatives of civil society organizations, ladies and gentlemen, good evening. I'm talking on the behalf of Denmark's research group on implementation of UPR recommendations. We investigate Denmark's implementation, in particular regarding the topic of migration, and we will present the state point of view and the civil society as well. Particularly, within a broader topic of migration, we focus specifically on detention, as it is associated with numerous recommendations and provides insights into how migrants are treated. In particular, we focus on the adherence to non-refoulement, the application of detention only as a last resort, and the efforts to improve detention conditions. As per methodology, we relied on reports, articles, and official sites for both state and NGOs' views. For example, we relied on Asylum Information Database, the European Agency for Asylum, the Council of Europe, and as per NGOs' part, we relied on Human Rights Watch claimings, Danish Refugees Council, and Council of Europe. Also, to gain and deep into food, we contacted NGOs and we have the replies from Danish Amnesty Branch, Refugees Denmark, and the Danish Red Cross Asylum Divisions, who gave us some insights. So I'm now going on behalf of the governments of Denmark, and Denmark has established, broadly speaking, a comprehensive asylum system in line with international standards, including the UN Refugees Convention and the European Human Rights Conventions. In particular, regarding the principle of non-refoulement, Denmark holds Article 33 of the 1951 Refugees Convention and its protocol, protecting individuals from being returned to the countries where they may face threats to life or freedom. This principle is central to Denmark's asylum processes. Also, the Danish Immigration Service ensures compliance with the non-refoulement by conducting thorough case evaluation. And furthermore, independent boards are actually available for appeals, enhancing legal protection for asylum seekers. Also, Denmark integrates the EU Qualification Directive into its asylum system, ensuring applicants can remain in the country while the appeals are reviewed. Furthermore, specific protections are in place for at-risk asylum seekers, such as unaccompanied minors and survivors of torture. So, regarding Denmark's commitment to detention as a last resort, Denmark has adopted legislation ensuring that detention is used only when strictly necessary, aligned with the UN Convention on the Rights of the Child and the European Convention on Human Rights. This law, in fact, emphasizes alternatives to detention, particularly for vulnerable groups like children. Also, Denmark prioritizes alternatives such as community service and rehabilitations over detention. The Danish legal system also is actively promoting some supervised release for individuals deemed low risk, electronic monitoring in order to avoid unnecessary detention. Furthermore, Denmark operates community-based alternatives to detentions for family and vulnerable individuals. And these centers are aimed to ensure dignified treatment for human beings. So regarding now Denmark's commitment to condition detention center, the government works constantly and closely with international organizations to ensure that the conditions with its detention center comply with the UN rule, ensuring human treatment and adequate living standards. Also, Denmark continues to invest in improving healthcare for detainees, ensuring access to medical care, such as mental health services. The country has been making consistent improvements in detention facilities, such as better hygiene and living standards. Lastly, Denmark has a robust independent monitoring mechanism, such as visits from human rights organizations, in order to ensure ongoing compliance with the human rights standards. So overall, the government demonstrates everyday efforts to align with the international standards and the convention rules. I will now give the floor to the civil society point of view. Thanks.
Distinguished delegates and representatives of civil society organizations, ladies and gentlemen, good evening. I will be reporting on behalf of the civil society in Denmark. First, I will be addressing non-refoulement, which was the topic of the recommendations 60.252, 60.253, and 60.254. Non-refoulement is protected under Article 33 of the 1951 UN Refugee Convention, which was ratified in 1952 by the state of Denmark. It is also protected under Article 3 of the 1984 Convention Against Torture and Other Cruel, Inhumane, or Degrading Treatment or Punishment, which was ratified in 1984 by Denmark. I will be focusing on two specific cases that have drawn the attention of the civil society in Denmark. First, the case of Syria, where certain areas in 2019 and 2023 were declared as safe to return to by the Danish Immigration Service. These were declared as safe as they do not experience the same amount of combat as other areas. And this resulted in the removal of temporary protections of refugees. And since 2019, 150 Syrians got their temporary residence permits revoked. The UN Refugees Agency released an assessment stating the objective circumstances in Syria, including relative security improvements in parts of the territory, are not of a fundamental, stable, and durable character so as to warrant cessation of refugee status. Therefore, this development is very worrying to the civil society in Denmark. The second case is the externalization of the asylum process to Rwanda. In 2021, the Danish government and the Rwandan government entered into formal talks about the externalization of asylum. The UN Human Rights Council has pointed out the incompatibility of externalization with international human rights obligations. There's also fear of inhumane and degrading treatment that civil society colleagues, such as the Danish Refugee Council, have warned about. The second topic I will be addressing is detention as a last resort, the topic of the recommendations 60.261, 60.263, and 60.264. First, I want to address the unlawful detention based on false documents, which violates Article 31 of the 1951 UN Refugee Convention, and in Denmark results in 40 days prison sentence, a 3,000 euro fine, and can impact residence permits and later on citizenship. This is very worrying as this violates international human rights obligations. Second is the detention of vulnerable people, such as victims of torture, trafficking, pregnant women, physically and mentally ill, and the elderly. There are long waiting times and superficial screenings, as well as limited psychological and medical care at detention centers. This can constitute a violation and constitute cruel and inhumane treatment. It has resulted in numerous suicides, suicide attempts, anxiety, and depression among detainees in Denmark. The last topic I will report on is the conditions in detention centers, which I already briefly touched on. The topic of recommendations 60.248 and 60.262, 60.265 as well. Here, the focus is mainly on Ellebæk Center, which is the main detention center in Denmark. Here, migrants have reported to civil society restricted access to the outdoors, mainly due to staffing issues, which will especially impact women in the detention centers. And the second is the right to mobile phones being violated, as the Østre Landsret affirmed that detainees are not serving a sentence and therefore have a right to their phones. However, detainees are still subject to prison rules, and the result is a 15-day solitary confinement for those that are caught with their mobile phones. This therefore results in detainees being forced to use landlines, which might violate their right to privacy under Article 17 of the Covenant on Civil and Political Rights, and can prove very expensive to keep contact with outside world as well as loved ones. Denmark must reassess its policies to ensure full respect of international human rights standards and address these possible violations that have occurred in the current asylum system. Thank you.
Excellencies, distinguished delegates, and representatives of civil society organizations, ladies and gentlemen, good evening. Today we will discuss Libya's efforts to address migration and human rights issues. Specifically, we will examine how the country reacted to recommendations from the third cycle of the Universal Periodic Review, focusing on key areas, including the protection of refugees and migrants, and the efforts to combat human trafficking. This analysis is based on reports from international organizations, local NGOs, and reputable media sources, with a focus on Libya's 2020 national report for the Universal Periodic Review. Direct information from the Libyan government was often unavailable due to the country's political instability, which is caused by the conflict among the Western Government of National Unity, which is the one recognized by the UN, and the Eastern Government of National Stability, led by the Libyan National Army. This complex situation also undermines the work of NGOs and the support of the international community. But in order to make up for this, findings were cross-checked with data from diverse sources. Thank you. I am now going to speak on behalf of the government of Libya, in particular, representing only the government of national unity. So the actions committed by the government of national stability and the terrorists it controls will not be addressed because we are not responsible for them. As we stated in paragraphs from 70 to 76 of Libya's latest national report, we took some concrete actions to address the notified issues concerning migration. Firstly, it has been set up the Directorate for Combating Illegal Migration, and the post of Assistant Undersecretary for Irregular Migration has been newly created in the Ministry of the Interior. Its main work is focused on the borders control and the prevention of the country being used as an illegal transit corridor. In addition to this, it organized some training sessions for hundreds of staff members to educate them on how to handle migration issues and to raise awareness about principles of human rights. Moreover, already in 2019, the House of Representatives passed Decree number 90 regarding the formation of a committee to develop a national irregular migration strategy. The Libyan government also actively implemented a non-refoulement policy and worked with organizations like the IOM to support the voluntary return of migrants. Furthermore, the Libyan government is involved in a partnership with IOM as well as other organizations such as the International Committee of the Red Cross. And this collaboration is specifically aimed to improve the living conditions inside the detention centers. Lastly, the government is working in partnership with the UN support mission in Libya to develop a new strategy to address the issue of irregular migration, focusing on stricter measures against smugglers, enhancing human rights compliance, and integrating migrants who wish to work. In fact, there has been progress in implementing bilateral labor migration agreements with Egypt and Niger to establish safer and more organized migration routes. Despite all the efforts described to implement these measures, we are aware that several international organizations have reported flows and limited progress in the proper functioning of the procedures initiated. For example, cases of corruption and exploitation in detention centers, even involving state officials. However, as I just described, overall an ad hoc reform system has been implemented and we trust in its gradual improvement. I will now leave the floor to the NGO's point of view representative. Thank you.
Excellencies, distinguished delegates and representatives of civil society, ladies and gentlemen, good evening. Taking into account the Libyan government statement, I will report the NGO's view on UPR implementation. For starters, human trafficking remains a major issue in Libya despite the creation of the Directorate for Combating Illegal Migration. In fact, as reported by Amnesty International, the DCIM faced allegations of corruption and involvement in trafficking networks. So overall, the DCIM structure seems to have become a source of impunity for traffickers and ongoing abuse for those who it was meant to control and protect. Secondly, despite the adoption of Decree number 19, which is aimed at developing a national strategy on irregular migration, according to the data that we were able to retrieve, progress remains minimal. In fact, the lack of transparency and accurate implementations weakens Libya's declared commitments, and this is not in line both with the international law and with the objectives presented in the decree itself. Moreover, the Libyan government states that it implemented a non-refoulement and voluntary return policy. However, concerns have been expressed about the government's criminalization of all forms of irregular entry, stay in, and exit from the country. This extensive criminalization weakens protection for vulnerable population, further punishing potential trafficking victims and impeding adequate humanitarian assistance. Then, although the collaboration with the IOM has resulted in some positive changes, various humanitarian organizations criticized the insufficient research and rescue operation and the inhumane living conditions faced by migrants. For instance, Amnesty International reported that detention centers are overcrowded with frequent cases of abuse, forced labor, and sexual violence, including rape and forced prostitution. Ultimately, the government is effectively working in partnership with UN support mission in Libya to develop a new strategy to address the issue of irregular migration. Nevertheless, reports continue to reveal inhumane conditions in detention centers and aggressive arrest campaigns against migrants, often resulting in arbitrary detentions, family separation, and active smuggling networks. In fact, many NGOs confirmed widespread sexual gender-based violence against migrants and refugees, and also indicate how traffickers frequently evade arrest and trials. Thank you.
Okay, thank you. And so this was the first part of this afternoon, in which this group presented the situation of 3 countries and based on the outputs of the 2020 UPR. And you know, the description of the situation is made taking the viewpoint of the state officials, state governments, and the viewpoint of non-state entities. Okay, and this on purpose we asked not to draw any conclusions from this discussion, from this research, because actually the conclusions are for the UPR to take. Okay, so now we move. I hope invite Mohamed Kheir to join me at the table, because we start another moment now of this afternoon, which is, let's say, a more classic, scientific conversation with you scholars and you know, officers of the UN that may, in this situation, in the context of you know, academic interchange, share with you their viewpoints, their knowledge, their wisdom, and their experience in many issues that you have encountered in studying human rights issues, human rights situations, etc. Not only concerning the topics that we have just dealt with, migration, trafficking, etc., but any other topics that was discussed yesterday and before yesterday in this setting. So we are happy to host Laura Dolci, who is online. Thank you for joining us. Okay, there should be a way of...
I'm going ahead and maybe a couple of words. So first of all, thank you for hosting this every year. And I see a room full of students. I noticed that there's a lot of women in that group, which is in line also with what we are seeing now increasingly in the UN room. So well done to the next generation of diplomats and human rights defenders and civil society representatives that we will have coming from this group into our rooms in the future. You seem to be a group that has done a lot of in-depth work. I was really impressed already by just listening to some of you. I'm Laura Dolci, and I'm the secretary of the UPR working group, and I work with Mohamed, who is one of the colleagues we have in our team that is coordinating some countries and is preparing the reports and then is following up on the countries. As you know, the UPR is a full cycle. So right now, of course, you are in the phase of what we call adoptions by the plenary of the council. Since I have the floor, and then obviously, if I hope to be able to hearing you, any question is a good question, but let me maybe give a couple of immediate comments to what I just heard in the last 5 minutes. You're better than the delegates we hear in the room. I wish we had more of that in the room. UPR, as you know, is very regimented, the proceedings, and this is why it works. And it allows 193 UN member states to participate and to participate on equal terms. So unfortunately, in the room, during the proceedings, we are very strict, and that's the word to be used, in terms of the lineup of countries, the minutes to be speaking. I'm the one on the podium with the timekeeper. So a first technical detail, the time is very important. UPR is the one segment, item 6, where NGOs get to speak slightly longer than states. NGOs, they speak 2 minutes, and states, they speak 1 minute and 30 seconds. And of course, the state under review has more time, has 20 minutes. The trend that we see right now in the room, so that's why I'm giving you feedback as compared to this very in-depth work that you did. We see states, so the state under review, coming for the adoption, making more or less the full use of the 20 minutes. Some of them limit themselves to explain how happy they have been and how useful this UPR exercise has been to them. Some use the time to already announce some of the measures that they are trying to implement and they started to work on. And sometimes they even go further in explaining some other voluntary commitments that they would want to take since the time of the review. Some do quite a good job. Of course, it's a peer review exercise, so that means that states keep learning in a sense from each other. And so we've been seeing a bit more of an introspective attitude, but of course not from all states. So some states come and they go quite at length to try to explain the positions that they have taken on recommendations and the process that has led them to take such positions. Of course, we have in writing the addendum, but the addendum very often is very difficult to follow. So we encourage states to use the time to share the process that they had, but also the reasons why they went ahead to take on board quite a good number of recommendations. On average, we have 75% of acceptance rate throughout the 193 countries, and that's a percentage that has remained more or less the same since the beginning of the UPR history. Some states, of course, take time also to explain why they haven't accepted certain recommendations, and then, of course, in a context that is an interstate context, hence it is political by definition. Some, of course, also like to explain sometimes why they have rejected, and they use words that we then don't necessarily reproduce in the proceedings, certain recommendations. What we are seeing, unfortunately, when it comes to the other states taking the floor, as I said, there is a 1 minute and 30. and not many get to speak. But believe it or not, on average, this 1 minute and 30 is being used even less. We have statements of recommending states taking the floor for 40 seconds to simply congratulate in a very nice way the state for its accomplishment, for having undertaken its fourth, because we're now in the fourth cycle, UPR cycle, and wishing them all the best for the continuation. So it's getting quite thin in terms of content. Of course, some states still take the time to, of course, congratulate. Always, it's a diplomatic room, but they sometimes refer to some of their recommendations, and they express regret for their recommendation on A and B having not been accepted by the state, or they recognize that the state under review has accepted a recommendation that they put forward, and they're quite happy about that, and they go even to expressing their intent to provide them support in the implementation of that recommendation. Where the voice is very critical is the voice of NGOs. Normally we have 20 minutes for the segment of NGOs, so it means that divided by 2, 10 NGOs can take the floor. And normally, especially for large countries, we have no problem filling those 10 slots. But even there, we notice that sometimes we have to run a bit after civil society to make sure that they bring in a voice. And of course, when we have NGOs taking the floor, and the colleague there right now did it very well, the statements normally are quite deep in content. Of course, we advise NGOs to contextualize their statements, so, put them in the context of the UPR, review, make reference to, positions that the state has taken, or, express concerns because the state has not accepted a number of recommendations. Here, since the time of COVID, and we still have it, we have the possibility of delivering statements in person, which was basically the situation for everybody up to basically the start of the COVID. And then because of COVID, we introduced online means. Now the online means, we no longer have the possibility of Zoom, because states have not agreed in New York for hybrid modalities. But the video statements exist. And so the possibility still exists. And so in the segment of NGOs, we still see several NGOs opting to deliver their statement by video. And that is actually quite interesting because, as you know, it's only NGOs in consultative status with ECOSOC that can participate in the plenary sessions of the Council. And so you would, let's say, have Amnesty International having enlisted to speak, but the speaker that is online on video, so we have this big video in the room, is actually a national of the country that is being reviewed, let's say Uganda or Italy. And so the voice that comes across is a voice from the ground. And sometimes the statements are quite strong, but because the person that delivers it is not, the Geneva accredited NGO delegate that would deliver several statements on many things, but it's somebody with a voice and a face from the country. The country which sits at the podium tends to stay silent and not react. In the past, we had situations where a state obviously gets upset because an NGO uses too strong of a voice. But in general, when the voice is really one from the country, the state has a bit more reticence to jump up. Another thing that we've noticed now in the adoptions, we have more interest on the side of UN entities and sometimes also resident coordinators of the UN system to intervene. Of course, because it's 20 minutes, there's an extraction by drawing by lot, so not everybody can speak. But we see now UN agencies that are interested in speaking during the adoption because themselves, as you have learned, they are now implicated in the UPR more and more. They see the opportunities of the UPR. So sometimes lately we've been having resident coordinators putting up a video thanking the country for the cooperation, putting up front a read of their accepted recommendations, and then already advancing that their intent to be there at the ground waiting for basically the outcome to come back at the national level and work with the country for the implementation of some of the key commitments that the country has taken up. But as I said, the adoption goes quite fast, and it's really paced. The trends that I repeat we see, which are not positive, is that in terms of participation in the room, the peer states, what they had to say, basically, they have said it at the review. And so the time of the adoption, we don't hear often states saying really additional comments rather than thanking the country and wishing the country good luck for the implementation. So I stop here for now, and I'm hoping that in the meantime, I'll be able to listen to you. So if you give me a second, I'll play around with the mic again, the sound, and see if I can hear what you are going to say. I'm sorry for this.
Okay, thank you. I hope she will be successful in setting her computer. And so maybe we can start in any case to take some questions from the audience and ask perhaps Mohamed to give some responses or to give some feedback. Mohamed, if you can say just a few words about yourself. Many of you have already had the opportunity to meet and to talk with him.
Thank you. Thank you very much, Professor. Thank you all for welcoming me to your team here, to the center. I think I've had a chance by now to converse with most of you, and perhaps not all of you, but I'm really, really pleased to be here. I'm really impressed by what I saw yesterday. I was joking with Laura. I said some of the presentations here are far better than the ones we hear in the actual council. So I'm really impressed. And as the professor and Laura mentioned, I'm working with the UPR since a few years now. I'm Sudanese. I've in my previous capacities worked mostly with the regional division of our field operations and with commissions of investigation into allegations of violations, especially war crimes. So the shift to working directly with the council and with one of the major tools in the council is like going from one extreme to the other. The UPR is a very cooperative, soft tool that seeks to promote engagement and compliance. Other elements within our office and within the system are frequently perceived to be far more confrontational and in many ways offensive to those whose actions and conduct is being investigated. So I've learned a lot working with the UPR because of the opportunity to engage with governments in a much more open manner. So yeah, that's me. And I'm very happy to answer any question. I hope Laura can also hear us or will hear us very soon, so she can also come in. Thank you.
Okay, can you confirm that Laura is also with us? Can hear us?
I can hear you, and I hope you can hear me now.
Yeah, excellent.
Thank you.
So thanks a lot. Thank you for your presentation. Now the ball is in the field of the audience here, the students, and also our colleagues. I mentioned that Professor Gerd Oberleitner is here from the University of Graz, and also Professor Anna from the University of Wrocław, Poland, and there are also some of our students here in the room, as well as students from Graz, of course. Yeah, who wants to start? One there, 1, 2, and 3. Yeah, 4.
Is it on? Yes. Hello, good evening. Thank you to both of you. And I was wondering from your positions, you witness many states making commitments and pledging, et cetera, et cetera. And I was wondering, how do you navigate the gap between the words and the actions that in the UPR process? Like, is it frustrating? Like, how do you navigate this? Can you do something for your position, or it's all in the hands of the lobbying? Thank you.
We can take also 2, 3 more questions. So one is there and on the back. And you, okay, 4 questions to start with.
Hi, everyone. I'm Alicia Stari, here representing the delegation of Armenia. And I would like to thank you for your words. And I would like to connect to the question of my colleague. In fact, I would like to ask the recommendations that states made are not binding. So how can we make more pressure and like use more a coercive force in the concrete implementation of these recommendations? Because on paper, states sign many conventions and treaties, but in practice, they retain in their national programs to concretely put an effort in making legislation to advance human rights violations. So how can we reinforce this like coercive force, even though recommendations are not binding? So even considering that there are some alliances indirectly among states through lobbyings and etc. So thank you.
Can you stand as well? Yes, thank you.
Good evening, everyone. My name is Denise Mendoza. I'm a student of the 2nd year of the master's degree of human rights, representing the Greenpeace International Organization. So my question goes to both of you, and is like, as students of human rights who have actively engaged in this UPR simulation and have seen everything in the process and have drafted the plan and the lobbying and everything, in your view, what are the biggest challenges that new human rights advocates like us should anticipate in the current global landscape? And how can we best prepare ourselves to address these challenges effectively? Thank you.
The last question here, the forefront.
Okay, thank you, Dolci. It's truly an honor to hear your insights. I'm representing the delegation of Kenya, and we deeply appreciate the opportunity to participate in this important UPR session and your guidance. And as we reflect on the challenges of implementation, and we would like to ask for countries that fail to effectively implement UPR recommendations, and what mechanisms does the Secretariat secretly have in place to ensure accountability? And additionally, are there any plans to introduce measures such as incentives or censures to ensure compliance or strengthen the overall effectiveness of the mechanisms? Thank you.
Thank you. I think there is enough food to start. Maybe we can give the floor to Laura, since the system seems to work.
Thank you, Professor. Thank you. Well, very critical questions, and questions that, in fact, of course, speak to the UPR, but I feel that, and this is a shared concern and feelings, I think we are all faced, and I'm thinking of course, the youth, without any condescending tone. I mean, we are faced in front of a geopolitics that is moving very fast and not necessarily in easy directions, and there's a lot of threats. And what we are missing is trust and trust in multilateralism and the architecture that we built together over the years after World War II seems, and the governance that we have given ourselves seems to be fragile these days and not fit for purpose anymore for having an ability to really sit people around the table and find common solutions. I mean, we turn on TV these days, and I think we're all a bit numbed by seeing, you know, more images of rockets and landmines and you name them, rather than other items. So yes, it is not easy, and of course, as the colleagues were saying, these are social. It's a social construct. There is no enforcement. And I think, and I want to go back to what Mohamed was saying, of course, when you look at the UPR, the strength of the UPR has to be seen, you know, in a sort of mutually reinforcing ways with other mechanisms. So one answer to the question is that not put all your strength, all your efforts in one direction. One technique probably is to try to pursue also different avenues of engagement and mechanisms, because some things can work through the UPR, but some other things, of course, can work through individual complaints, and some others can work by having, you know, stronger treaty bodies and better experts sitting in treaty bodies, appointing the right special rapporteurs, having some critical visits by special rapporteurs. So if you try to then take all the pieces, you may get, you know, some incremental and marginal advancements. Of course, what the UPR has is this peer. It's a peer interstate, of course, mechanism. But peer means also peer pressure. And I think over time, you know, the UPR is not as old, but first of all, and we overstate it, but at the same time, it's something to be said in the right sense. I mean, it's the one place where everybody participates. And this is a value that I think these days is even more of a value than 15 years ago. I mean, we just finished a session where, you know, between one and the other, but we had Nicaragua, we had DPRK. So it's still a room where every state comes. And this is, in the current context, something not to be underestimated. The other thing, of course, is that what I was saying is the learning and the pressure, because it's a game where after 3 cycles, I think everybody understood that at a certain point, everybody is in the chair of the other. It has a value, for instance, for small states, the small islands, the least developed countries, because you have to try to imagine that for a small state coming into a room where the whole assembly is there, and you can be, you know, San Marino or Samoa, and you have you know, Nigeria giving you something, or you as Samoa, you can give a recommendation to the US. So it's a platform sometimes that, you know, it's an important platform for all, but in the current context where a lot of small voices are being lost in this geopolitics that is so frenetic and scary, you know, the UPR, so somebody before, you know, Greenpeace, you know, for instance, the UPR, through the good lobbying of some, has become also the place where human rights and climate change came in, because it started from small countries bringing their issues of the impact of climate change on their communities. And now we see an increasing number of recommendations to one another on this issue. So, so I think it's as I said, this peer pressure and this peer learning is, in a sense, makes up to the gaps that we have because it is not an enforced procedure. States are increasingly also looking for technical assistance and capacity building to, and this is where technology, if used in the good manner, is very necessary also in human rights, on how to track progress. So they want databases where to put, you know, all the recommendations of the UPR and the concluding observations that they receive from treaty bodies to track where they stand. And increasingly, and this is also good things, we see states seeing the UPR and their commitment in the UPR as all-encompassing state architecture exercise, because it has to be. You have to have the parliaments on board, you have to have different ministries, you have to have the judiciary, even if you want to pass certain changes also in the rule of law system. So we see more delegations coming to Geneva that are composite, so not just gender and other types of diversity, but also bringing the different parts of the state architecture. And then going home, this is why technology is important, because if you have, you know, good tracking system that allows to also track progress by each of the state entities that has been assigned in trying to see where they are in the implementation of recommendations, that's very key. There's also a need to prioritize, I think, and states go home, especially small states, with a long list also coming from treaty bodies. So, I mean, I think it's you know, unrealistic to think that a state after 4.5 years can come and say, I have positively enacted all these recommendations and I have positively made progress everywhere. Where states also learn a bit, not all, in UPR, is also an element of introspection. You hear now more states coming back, also capable of saying what they haven't been able to implement, which is also important. I mean, it's a constructive dialogue, and you know, it's not one where people should come and only brag about what they've done. Of course, the monitoring and the accountability comes from many stakeholders. Of course, we as Office of the OHCHR, we are present in many parts of the world, but we have now the UN system that is coming on board with the UPR and understands that it's a possibility of engagement with states much more than they thought at the beginning. And of course, civil society and other players. Where we don't have a good record as yet, in my view, and it's very good, you know, thinking of your university, is that the UPR has not gone down to the communities, it has not gone down to the universities. You know, it's really not covered by the media. That also happens for other mechanisms. I think we should have public viewing of what happens in that room. Because at the end of the day, even the big states, even the more virtuous states, or these days there's nothing like a virtuous state anymore, but they tell you it's good to come to the UPR because it's like a medical checkup. You know, every 4 years you sit and you have, you know, different experts and different views been looking at you and telling you. And it's also interesting for states of the global north to sit in a room where all of a sudden you can have a recommendation from a completely different country and from another region that tells you, hey, look, you can do better with gender parity in your country. Although, you know, your record is probably better than mine on that already. So, I mean, yes, no teeth, but I think the teeth comes by virtue of this, of this possibility of keeping the game open with everybody, and then leveraging, of course, the advantages that you can try to find from the various mechanisms. Clearly, you know, the fact that, you know, many states are cramping down on civil society takes away a lot of oxygen in terms of advocacy and monitoring. And in terms of incentives, I think there is an increasing demand now. States would like to put forward some good stories. I mean, at the end of the day, the UPR is a positive mechanism. And so we should do better to help states also putting forward and narrating good stories of the stuff that they managed to do. Then, of course, a state is a state, so a state has elections. Some never do, but some do. So sometimes we've been seeing states that came to the UPR with a certain government 2 years later, they have another. And then depending on the change of government, that's also something to be taken into account. Sometimes you have an acceleration of implementation because there's been a positive political change in the country. And sometimes in the 4 years, unfortunately, there's been a coup and the commitments taken, there's even less chance for them to be implemented. So it's a bit of a give and take. And in the end, with 193 countries, you have all sorts of situations. But I stop here for now, and I'm sure Mohamed can complement.
Thank you, Laura. No, I think Laura gave a really holistic response that touches on all the things that I would have thought about. And I think it's really useful. One thing Laura said is to think of the UPR as a mechanism in a much more multifaceted type approach by the UN, by international institutions generally. As Laura mentioned, one clearly visible dynamic is that the number of recommendations are increasing each cycle. I think now we've reached an average of almost 3 recommendation per speaker. We can see that our kind of support services are in much higher demand. So we're much more involved also in the implementation phase, so to speak. Of course, we cannot go and implement recommendations on behalf of countries, but increasingly governments, NHRIs, CSOs, NGOs, but also UN country teams, because the UN, as you know, has a large number of organizations, specialized agencies. Even within the Secretariat, there is ourselves, political affairs, humanitarian, etc. And the UN has been trying to neutralize this defragmentation that we have in the different countries where we work. And as you know, we have a larger presence in countries where there are more problems usually, where we are allowed. And so the UN's initiative, the One UN, has been bringing together all the different UN bodies and countries under the umbrella of UN country teams. And the UN country teams themselves are increasingly engaging with us. We are providing training to them. We are helping them keep track of progress in implementation of recommendations, not just by the UPR mechanism, but also by other mechanisms. And I think that whereas the UPR is not really, does not have any teeth, so to speak, the truth is even those organizations, for example, the International Criminal Court, it has teeth. They can issue arrest warrants against persons holding the highest levels in any government, but that does not allow them to necessarily bring home those indictees. It does not have, you know, a unit, a special forces unit that can travel into Sudan and arrest the president of Sudan and take him to The Hague. Similarly, with other bodies, Security Council sometimes can establish sanctions, but these sanctions are not always implemented. So there's always a question of there are limitations to what the UN can do, even those elements within the UN that have that are supposedly more intrusive, and therefore it is very difficult to you know, to say, okay, these recommendations were not implemented. The UN was unable to enforce the implementation of recommendations. Therefore, the entirety of this exercise is useless. I think that's not really the case. I think, as Laura mentioned, there are growing challenges to the notion of having international law and an international-based system. But I also think that, and we were talking about this with the professor this morning, there are also interesting dynamics that we should allocate in a broader, more historic context. For example, 20, 25 years ago, many countries, especially from my part of the world, you know, East Africa, Middle East, showed absolutely no consideration to human rights. They would just very frankly come out and say, human rights is a Western invention. We don't care. Keep it away from our shores. Stop bothering us and walk away. Today, we're seeing a different trend. So we're seeing countries being involved. We're seeing countries engaging at the level of the UPR and at other levels. Then the implementation is still lacking. So there is what some people, dub in a bit cheeky manner, human rights diplomacy as well, like to try and project an image of caring about human rights while actually not changing anything in the ground. But the very fact that you have countries, I can say an example, Saudi Arabia or Qatar or others, that are investing so much in projecting that image of, caring about human rights and implementing reform, what does it tell us? Essentially, it tells us that even countries that don't have a tradition of promoting human rights, at some level, they're aware that it matters. It matters to the way others perceive them. It matters to their capacity to engage with other countries. It matters even economically. I have friends who work with private companies that do analyses and assessment of countries where businesses, they basically advise businesses, it's safe to do business in this country, or this country is not stable. And one of the things they look at is stability, the legal system, and also their human rights record. And I've had people call me and say, like, where can I go look up things about country X? We have clients that are interested in investing there. They want to set up a business, a factory. I don't know. They don't know if it's high risk or not. What's the human rights situation? So I direct them to the reports of the UPR, which are quite comprehensive. They address all manner of things. And then also, I think it's important to realize one thing, that countries, most countries, even countries with dismal records, they don't necessarily have an opposition to every recommendation. So countries where there are war crimes or recurrence of violations such as torture, ill treatment, arbitrary arrest, whatever, they might feel a bit threatened when touch certain things. But recommendations relating to improving accessibility to schools, improving access to persons who have disabilities. There's a whole range of issues that governments don't necessarily perceive as threatening to them. And they are usually happy to accept these recommendations and try and make progress in these recommendations. There's one question I found more or less your question and the first two about the discrepancy between commitments and implementation and how to address them. And I think, this is what Laura addressed, and this is what I tried to address as well. I think one thing that I can add is the increased coordination and advocacy efforts by civil society. We're also seeing civil society increasingly using accepted, the recommendations that were accepted by states as an advocacy tool. Because once a state comes out and supports a recommendation, well, then, that's one step less for civil society. They no longer have to persuade the country that this is a commitment worth making. The country has publicly made that commitment. They can come and say, okay, let us help you. Let's work together. We want to provide any assistance we can. And so it takes us one step closer. But at the same time, I think when there was a third question about the challenges, what challenges can be expected? I think the challenges that I see are tied to what we were saying now, that many countries now are becoming more capable at providing lip service, at saying we care, we listen to you, we're trying to make changes, and then they don't, necessarily have the willingness to implement. So it's becoming a bit more tricky in that sense. It may begin to become less obvious that countries are, determined not to make implementations. I think now increasingly governments will make commitments, and then they will try to find ways of either not implementing them or not implementing them in its entirety, but justifying it in ways that make it seem more plausible. So I think that, together with false information and all these things that we're seeing, are probably the biggest challenges, yeah. And the changing power dynamics, I think, you know.
Yeah, thank you. Thank you for stressing this last point, because it's actually the reason why we started 2 years ago to complement the model UPR that simulated the, you know, the discussion, the diplomatic work that people do in Geneva. We associate to that also a research work on the implementation. So check the data, the information, the what actually states are delivering, you know, in as a let's say in the implementation phase of the previous cycle. And this was I mean, documented in the first the presentations that we had this afternoon. I think there is time to take some more questions from the audience. Second round, 1, 2, 3, 4. Okay, 1, 2, 3, 4.
Thank you, Mrs. Dolci and Mr. Mohamed. It's an honor to hear your insights, and we deeply appreciate this opportunity to engage. While the UPR process recognized the valuable contributions of NGOs and NHIs, we have observed certain limitations in their involvement, because their recommendations can be adopted or disregarded at the discretion of the state under review. How can their participation and influence be strengthened, particularly to ensure their input has a more substantial impact on the recommendations and outcomes? Thank you.
Hello again. So apologies for not doing earlier, but my name is Ilaria Babala, and I'm here to represent the delegation of Turkey. And connecting to what Ms. Dolci was saying about all the states participating to the UPR, since the UPR mechanism was constituted on a resolution of the General Assembly, which is not binding, I was wondering what would happen if simply countries decided to stop participating in the UPR. Is that a possibility or no? Thank you.
Thank you. My name is Dakota Zaylor. I'm here representing in this simulation the National Human Rights Institution of Kenya. My question's somewhat two questions, if that's allowed. The first being, today we lobbied as NHRIs and NGOs with recommending states in order to review the addendum, the working group addendum. And I'm just curious in reality what that process looks like. Because here it's, you know, somewhat structured because it has to be, but in reality, is it behind closed doors, happening constantly? And then my second question was on the topic of surprises. Once again, we've definitely had some surprises in our simulation, but I was just wondering if there's been any kind of key moments within the UPR, for good and for worse, where a state has somewhat used the system that it's operating in to its advantage or disadvantage. Thank you.
Hi, I'm Margherita, and I'm participating in the simulation, the UPR simulation, representing the delegation of Armenia. And actually, I have a question that regards more the UN in its general, not the UPR mechanism. And I'm wondering, since the UN is characterized by some states having veto power, what is your opinion on this? And if you think this assessment should change in order to the UN mechanism as a whole to be more effective? Because I see also what's happening right now. Actually, today something happened, and and I don't want to enter into too much politics, but I really as a young person interested into politics and international relations, I wonder how the UN can be strengthened, because in these years, we are seeing a decline in human rights institutions as a whole and their effectiveness and the collaboration of states. So I'm wondering what's your opinion on this? Thank you so much.
I think Margherita's trying to get Laura and I fired, but it's okay, we'll take it.
Okay, so apologies, we'll probably finish a little later than expected, but we can take the 2 more questions now.
Good evening, everyone. Thank you, both of you, for the insightful presentation and for making yourself available to answer our questions. It's really insightful to have the perspective of somebody working inside the UPR. I'm Francesca Zavia, currently representing us from international and civil society in the simulation. And during these days of simulation, it occurred to me that there might be some rights that are more discussed than others. And in your experience, since you work with the actual UPR cycle, have you noticed that certain rights may be particularly softer or less politically relevant rights are indeed less addressed in the UPR cycle? And in case, what should we do in order to have a more balanced approach to address all rights equally? And I thank you for the answer.
Hello, thank you both for taking your time as well. I'm part of the delegation of the Maldives, and I have a question, since you're both very much involved with the UPR. If you could give, so to say, recommendations to the UPR in general, what kind of recommendations would you give the UPR, and what would you like to see of like enhancements or change of the mechanics of the whole Universal Periodic Review? Thank you.
Okay. Good questions, quite tough. Who wants to start? Maybe you can start with, I don't know if you have time. Laura,
I can answer.
Yeah, thank you.
Yes, with pleasure. Indeed, they are good questions. You have very good students. You should all come to Geneva. We should be having you in the room. So the first, going a bit back also to the questions before, something that maybe I didn't say very clearly in terms of achieving progress, and relating it also to the question of how can you not feel frustrated, and how can you put up a good face yourself in front of, you know, what sometimes appears a big gap between what is said and what is done. In addition to what was said before and also by Mohamed, I think really the UPR, and that's probably not a satisfactory answers for you, and, you know, youth wants change right away, but the UPR lends itself more as an instrument where you can see progress a bit in the long term. It's not, although at times you can have a state saying, I'm coming here and I'm committing, I change government now, and I'm committing that with the new government, we're going to abolish death penalty. And they'll do it. But in general, the progress, you measure it a bit over time. And as I said, we're now in the 4th cycle. We saw states coming back, maybe receiving the same recommendations cycle after cycle, and then a maturity grows. And after a number of years, you know, there's a change in position, but more importantly, then something is happening on the ground. So one has to equip itself with a bit of patience when working in this line of work, because, you know, the result may not be immediate. And sometimes we can have some results being, you know, unpacked in the reverse order. But there is a steady progress. And I think progress in the long term sometimes also is more difficult to measure, and instruments are really lacking. But I wanted to add this reflection. Now, on the issue of NGOs, of course, the frustration is that, I mean, the good and the bad, if you wish, of the UPR is that the UPR is by definition an interstate operation procedure. So it's states to states speaking to one another at the time when the resolution, the GA resolution was negotiated, and then the famous Council Resolution 5.1, which started to outline a bit the mechanics of what this UPR will be. The door, there were really tough negotiations to keep the door a bit open for civil society. So that door is a bit open. There are spaces for NGOs to interject, to input. Of course, the most important one is, of course, the written submissions, is the advocacy. As I was saying before, in the adoptions, we hear, and it's recorded, the strong voices in the room. But then, of course, it's the work on the ground. And I think strong NGOs, and they can be big and small, you know, they take the recommendations, they look, they analyze the position. Sometimes they pick a few, and then they start hammering the country and holding them accountable. And so whether the space is being reduced, I don't think so. I mean, it's been a space that from the start was not primary, but NGOs have learned how to use it. They still need capacity. We help them, we support them, but it is not, you know, as a start, a mechanisms where NGOs really have a primary seat. Of course, we need to protect the space of NGO. We need to protect and make sure that their participation is safe. We have situations where, of course, and that unfortunately is an increasing situation, and not just with the mechanism of the UPR, you know, NGOs stand up, they expose themselves. And so, unfortunately, you know, the reprisals are very much something that we see for states, for NGOs, against NGOs that cooperate with UN mechanism. But we, you know, we are human rights officer. This is the office of the High Commissioner for Human Rights that supports this mechanism. So in our DNA, also as individual human rights officer, we have that very much at heart. So sometimes we fail, but in general, we try to make sure that the participation is safe. The question of the distinguished delegate of Turkey, it's an important one. It is, of course, soft law. It is, like anything, a soft mechanism, but the UPR has several ingredients that make it that so far it has seen full participation. One, I think, is the predictability. You go online on our calendar, you already know which country will appear, not even the year, but the month in the next 8-12 years. So I think this predictability, give and take, you know that in 4.5 years you come back. 4.5 years can look like a long time, but it is not. So, and you know that in 4.5 years, you're expected to say something positive that you have done. So you don't have any country that will appear to do either a no-show or a show with very little content. So by now, I think this is understood. The other thing is, of course, the equal treatment, big and small, and sometimes this is frustrated, but every single state applies the same rules of the games. And I think this, which by now has also characterized and all of us, also a civil servant working for this mechanism, there is an element of trust that has been built over the years, because it doesn't matter if you're Vanuatu or if you are Russia, you have exactly the same in every single thing that we do. It's the length of the reports, the speaking time, how you sit people in the room. Every single state is treated in the same manner. And this is something that takes away this element of bias, which inevitably we have in multilateralism, where you feel that certain countries are bigger and more powerful and others are discarded. So I think, and we are very, very careful as Secretariat to make sure that this is completely part of the way we also operate. And we try to keep, our own, personal judgments for ourselves, we deal with every delegation and we treat them in exactly the same way. And that has also guaranteed the success so far of the UPR. The other element is still soft law, but in Resolution 5.1, Article 38 has speaks of what happens in case of non-cooperation. So as light as this is, but this has worked. We have not had a single country that in the end didn't come to the UPR. There's been some attempts and even requests for postponement. The Bureau of the Council and the Council as a whole has been very, very careful of not granting requests for postponement. I mean, for instance, this cycle so far, we only had one request for postponement that was granted, and it was to Ukraine. Ukraine was due to be reviewed in, I think it was January 2023. So of course the war the war of aggression against Ukraine had just started. But that was brought, is brought to the attention of the president. It's then discussed at the Bureau, and then it requires gaveling by the whole plenary of the Council. So in the end, we can count requests for postponement granted on the fingers of one hand. And so far, we never had a situation of non-cooperation, even at the times when the US, and we are a bit afraid that it's going to happen again, the US pulled out of the membership, pulled out of the Council, it still came to the UPR. There was one attempt by Israel to boycott everything, including the UPR. But in the end, there was pressure by the Council. There was a letter written, and in the end, they came. So it's a small thing, but the fact that it's written, so there is, like some sort of looking down if somebody is not cooperating, has put enough pressure for everybody to cooperate. The issue of sorry, I'm speaking a lot. I'm sorry, Mohamed, I will leave you the floor. The issue of, going back, the question of the distinguished delegate of Armenia is, I think, going back to what I said. I think the governance that we have given to each other as an international community at the end of the Second World War clearly is not fit for purpose right now. The frustration that we all feel, and I think you as young people is even more. When you turn on TV, the one image then again and again we're seeing is that one image of the Security Council chamber, which is basically stuck. It's been stuck for years. And the youth and anybody in the world the headline is the Security Council failed again to take any action on this and this and this and this and this crisis. So the political UN is unfortunately no longer fit for purpose. What works still, but it's less covered on our news items, is the operational UN. The UN is still out there with hundreds of our colleagues delivering vaccinations, negotiating the passage of humanitarian aid. We have colleagues dying every day in line of duty in doing the job under the UN flag. But that UN flag, the UN peacekeepers, the Chapter 7, the peace and security, this is where I think we obviously have stagnation. And paradoxically, although the same colleague spoke about a weakening human rights system, well, there I'm not so convinced, because paradoxically right now, if you are in the Human Rights Council chamber, the Human Rights Council is a much more active body now than 10 years ago. There's many issues that should be at the Security Council, but they're actually migrating to of course, it has different responsibilities and a different way of operating and different outputs, but there's a lot of issues that should, in fact, be more on the agenda of the Security Council that end up, for instance, at the Human Rights Council, because the Human Rights Council, at least it meets, it moves, it has resolutions, it creates commission of inquiries, and it creates new special rapporteurs. So clearly there is a problem right now. And in any case, the Security Council, as it was created, right now we know not only have issues of peace and security, every single issue is interlinked. So you look at climate change, you look at global migrations. I mean, we are going to be 8.5 billion people in this planet. So that image of that stagnating Security Council obviously is not a response. And it's not the kind of table that will allow for global solutions to be found. You're right, Mohamed, we will lose our jobs, but I think if we don't speak openly in front of a group of young people, I don't see where else. And then two last point maybe. The issue of what gets covered, I think, again, it would be interesting to do in the statistics, but I think one of the things that makes the UPR also works is not just the universality of participation, but is the universal coverage of rights. I'm not entirely sure that we have more attention to economic, social, cultural rights than civil and political rights. Mohamed writes these reports and deals with a lot of recommendations. You may probably know more. Statistics is very difficult to maintain, but I think at the UPR, anybody can pronounce recommendation on any rights on the spectrum, the full spectrum of rights. And I think that's also something that that has made a bit the fortune of the UPR so far. And last question about what we would recommend to the UPR. I think there are two things here. One is we absolutely need to increase implementation. And going back to what was asked at the beginning of this session is also how we measure what is the concrete impact and how we measure it in the lives of peoples and communities, from what happened in room 20 of Palais des Nations down to the ground level. So implementation of recommendations is key, and I think it's very good that your program is looking at that phase. The other thing is this issue of learning between states, how really to bring up the good practices that have emerged over the years in the different parts of phases of the cycle of the UPR. We need also more resources. For instance, the UPR has two trust funds, one to enhance participation and the other one is to enhance implementation. And states fail to give contributions. So paradoxically, we have more and more demand. This is what Mohamed was saying, of states coming to us to say, we need your help to try to implement this and this recommendation. But on the other hand, we are missing the money to the instrument of international cooperation to really go and provide as assistance. Hence the importance of including the UN system in the implementation phase, because at the end of the day, the implementation of the UPR is not just a job of the Office of the High Commissioner, but the whole UN system should be gearing around it. The other thing is that the mechanics, so how things are working in the preparation of the reports, what happens in the room, the recommendations, the 5.1, Resolution 5.1 was written quite carefully, and honestly, in UN terms, it is quite a good one. And so when you take the annex of that resolution that outlines how the UPR should work, it's quite regimented and it's written, what I was saying, it's a bit like the game of the cards, the instructions, le istruzioni le regole del gioco, the rules of the games are quite well written. And it has worked well. So the problem now is that we know that some of it can be changed. As Mohamed was saying, we have more and more recommendations. So I think even the way we write the reports, there should be a way also to maybe write reports where we cluster recommendations that have already been recommended in past cycles. And so looking at the 5th, 6th cycle, I think there should be some mechanics that can be improved to keep the game, alive and not getting a sense of fatigue from delegates. However, that 5.1 was so well conceived and it doesn't only include UPR, it's the whole council, that a lot of states are a bit afraid of reopening, because if you negotiate, you reopen 5.1 and you try to change a paragraph, given the current context of geopolitics, it may be very difficult to find consensus, and you may actually open a Pandora box of others that want to review other things, not necessarily for the right intent. And so we are a bit blocked in that sense, because states are a bit afraid of reopening negotiations, although they see themselves that there's probably certain things that can be oiled and improved simply because things evolve in life. But since things were written in such a clear way, there is a bit of a concern right now that if you sit everybody around the table to say, what can we change with the right intent, then others may come up and try to unravel an architecture that somehow came out in 2006, 7, and 8. And given the current context, I'm not entirely sure we will have the same ability to reach consensus on a different human rights system. So I stop here. I hope I was clear.
Very clear and very effective. I don't know, Mohamed, if you want to add anything. There was a question about the surprises that may occur in the field of the UPR, if you had any.
Yeah. I'll try to address some of the, thanks Laura a lot, because Laura covered everything so thoroughly, and it really touched on the core things that honestly, these are the things we talk about, especially when we're frustrated and we feel that we would like to see more done, concerning the CSO's input, how it can be strengthened, I think we need to keep in mind always that this is a peer-to-peer exercise, as Laura said. So even CSOs should focus on that. CSOs usually come to us as an operational office, as a technical body, and to states, but to the states that are the subject of the recommendation. But in this case, there are the two phases. One is the phase pre-working group, in which I think the focus should be directed at the state, the council states that will be delivering recommendations. And I think that's something that many, at least from my experience, many CSOs have not yet made that step. And I've seen it in, for example, with Ghana. I was talking today to one of the participants that in the case of Ghana, before the review of Ghana, a bunch of NGOs got together under an umbrella. They traveled to Geneva. They arranged meetings with the European Union, the United States, Canada, Ireland, etc. And they knew very well which ones were the countries that had leverage with the government of Ghana. And they made sure to meet with them. These countries were very happy to listen to national NGOs telling them in first person the things they documented, their experiences, what their priorities are. Because I think many diplomats realize that sometimes we look at countries and judge them through our own lens. And from the perspective of our own priorities, it's important to understand what are the priorities for the people in Ghana. And that has influenced, I believe, a lot of the nature of the recommendations that these states then delivered to Ghana. So in the pre-phase, I would definitely encourage CSOs to focus on. And I would also always encourage organizations to operate under umbrellas, because I think their efforts are magnified when they are collective. Then there's the phase of implementation. NGOs are encouraged also to submit kind of midterm reviews, which are voluntary for states, but some countries and some UNCTs, UN country teams also have been submitting midterm reviews, because they give us a measure of what steps were taken, what success, what failures, what we need to focus on to make sure that states implement recommendations they accepted and committed to. Concerning what would happen if a country, I think Laura answered that really, really well. Behind closed doors. Behind closed doors, item 6, it really depends. So for example, when I joined a few years back, Many countries still took the time during the working group review to take a position on recommendations. And in that context, we had a little bit of influence because frequently, it happened to me with Serbia. They had a very large delegation representing all different ministries and bodies, and they were sitting there for like 6 hours straight until very late into the night, going one by one. And they're like, you know, somebody would say, and it was quite transparent to me because I could see like one of them would say like, we should accept it, the other no. And then there was a discussion. Of course, I couldn't understand, but they had a very kind interpreter who kept keeping me in the loop. And they would also seek my advice, you know. And so, of course, I was, being a human rights person, I'm always trying to say, well, you accepted that recommendation. This one is essentially the same. Why not accept it? Why not increase the rate of acceptance? It's going to look good for you. And you have sometimes a little bit of room, you know, it's not always the case. Now, I think many recommendations, many countries tend to take all the recommendations back and then submit an addendum so that they can consult more widely among themselves and among the different bodies within the government. And that leaves us a little bit out, but it gives us more time to engage and it gives more civil society. They don't take a position right away. They're going to do it within the span of 4 or 5 months. And those 4 or 5 months are a window of opportunity for us as a UN, civil society to come in and try and say, this is a priority, please accept this. I think it would look really good. I think we can help you implement it. I think it can do 1, 2, 3. And that's, you know, an added window of opportunity for us. Security Council is extremely frustrating. It's extremely frustrating. You cannot imagine how. You cannot imagine for those of us who sometimes will go to somewhere that it's really difficult place, documenting violations, working night and day, coming across people who have suffered the worst things you can imagine, visiting sites of mass graves, people who have tortured, raped, beaten, lost all their families. It's really, it takes a toll also on the people like us who do that work really heavily. And to, you know, come up with a number of recommendations that most states will support and civil society supports, and then one country goes like this and you feel it all goes down the drain, it's disheartening, it's devastating. Like you cannot imagine how pissed off it makes people, including us. So it's really heartbreaking. And also it's something that reflects negatively on the entirety of the UN. So you can have the UNHCR are providing for about 20 million refugees around the world. You have OCHA coordinating humanitarian help in some of the most godforsaken places in the world, taking enormous risks, as we are seeing in places like Ukraine and Gaza and Sudan. People, colleagues are dying. They're dying. And to have all of these efforts, and then the world looks at you. For us, we go to places to meet with victims, and we get a dressing down by people saying, you are useless. What are you doing? Look at what happened to us. You're not doing anything. But actually, there's a lot of people doing a lot of things, and it all will seem irrelevant once the Security Council and the political bodies fail to act or are simply unable to intervene in a way that is constructive. So yes, probably getting fired, but it's enormously frustrating. And I don't know what else to add. You can read many years ago, Kofi Annan in his final year published a paper called In Larger Freedom or In Wider Freedom, perhaps Laura can correct me, that
In Larger Freedom.
In Larger Freedom, where he's suggesting a whole range of reforms the UN, calling on the UN to make, primarily focusing on Security Council reform. So yeah, the political bodies need to be reformed. And as Laura said, more and more countries are coming to the Human Rights Council in Geneva because it is more essentially democratic, you know. Yeah, that's more or less it. I don't know if I left anything out. What kind of recommendations to the UPR? I think, as Laura said, like one of them would be definitely how we can help support implementation phase through technical support, capacity building, lobbying, advocacy, etc. The other would be to enhance the role of civil society. It's a balancing act. The adherence the compliance with the UPR is high because of the way it is structured and because it is a peer-to-peer mechanism, which also makes it unique. At the same time, we can also see that it's different. You know, if you have special procedures, treaty bodies, you have experts or teams of experts who will be the ones analyzing what's going on in the country and giving recommendations. But for countries that are somewhat skeptical or uncooperative, they can always hit back by saying, this is a political agenda, the special rapporteurs are political, they are owned by this or that state. You know, there's a whole list of dismissive kind of arguments, and we've heard them all, quite frankly. When it comes from other countries, it's very difficult. It's very different. It's like your report card at the end of the year does not only come from the professor, but your peers are judging you as well. And the dynamic is very different. You will take it differently, and they will deliver it in a different way because normally they don't want to hurt your feelings. Normally they want to keep you as friends. So they'll deliver them softly and they'll give you some soft recommendations. And within that, there will be some truth. And that's what we're focusing on. And how is it used sometimes? The second question, I think, how can it be used? Well, sometimes the UPR is like all other platforms. Ukraine and Russia are having a confrontation in the real world. They're having a confrontation on all the platforms, including in the world of the UPR, where they're going to come and they're going to use that to, try to make the other country look bad, basically. And we're seeing it between Lebanon and Israel, between all countries that have conflicts with each other. They translate into some shape or fashion also in our platform. I hope we answered everything. Sorry, I know we're scandalously late, but trying to do it.
No, thank you. Thank you very much to Laura for all your comments. And to Mohamed, of course, you took all the issues, you spoke frankly and, in a very open way. So I can trust, I hope, on your passions, because there is the third element of this afternoon that we have to address, and Caroline and Lydia that want to present a topic which is again about human trafficking, is done in cooperation with fellows in other universities in the framework of the ARQUS, and ARQUS is an alliance of universities of which Padova is a party, but also Wrocław and also Graz. And I remember, maybe one point can be underlined, that Lydia and Caroline as also members of the Secretariat, and they are among those that will evaluate you at the end of this week. So I'm glad to give them the floor for their presentation that can be maybe shortened, because they also had the chance to talk with some of you in the refreshment that they offered this afternoon. So, and we can actually applause again and show our appreciation to Laura Dolci.
I just wanted to say goodbye, and it was really a pleasure for all of us to be invited. Maybe next year I'll come in person, and I wanted to wish your students all the very best, not only for the continuation of this program, but of their masters. And of course, we are available to stay in touch. And really for us in the UPR and the UPR services at the Office of High Commissioner, your model and the involvement of academia and youth is really something that we not only we cherish, but we would also like to take lessons, try to see if we can also involve other universities in other parts of the world. You have led and piloted with such a vision. So I hope we will continue this important partnership, but really this is really a big applause to your students. I was only capable of capturing a few presentations, but it's the depth and the enthusiasm and the diligence. And one last word, this is not the time to lose enthusiasm, and it's not the time to drown in frustrations. The world is not a good place right now, but you know, you are so well equipped, the young generation, to come on board. So don't get frustrated now. It's actually the opposite. We really need to stay militant and committed. And so with this, I wanted to say goodbye.
Thank you.
Bye-bye. Bye, Mohamed.
So we all subscribe. Standing invitation to you. Yeah.
Thank you. Thank you. Bye-bye. Bye-bye. Have a nice evening all. Bye.
So, Lydia and
Good evening, everyone. Excellencies, distinguished delegates, representatives of civil society organizations, ladies and gentlemen. Today, I'm honored to present the project Understanding Human Trafficking, a resource for awareness and prevention, which I developed alongside my colleague Caroline. The initiative was supported by ARQUS. Our project was born from a shared realization. Human trafficking remains one of the most shadowed and misunderstood global issues, despite its devastating impact on individuals and societies. We wanted to create a resource that would raise awareness and offer accessible, practical information about this issue. In collaboration with the University of Granada, specifically with Diana Ordóñez, who focused on Spain, we began by studying United Nations reports, the Greta report and Universal Periodic Review recommendations received by Italy and Spain in their last review cycle. These sources provided crucial insights into the legal frameworks, challenges, and progresses in combating trafficking in both countries. To deepen our understanding, we visited an Italian NGOs that actively combats trafficking. This allowed us to see firsthand the vital work being done to support victims and address this issue through legal, social, and educational activities. The result of our work is the creation of an informative booklet designed for students and citizens. This booklet aims to make information about human trafficking more accessible, focusing on recognizing the signs, understanding the legal frameworks in Italy and Spain, and knowing how to seek help. Importantly, it also highlights the incredible efforts of cooperatives and organizations that fight trafficking daily. To ensure that it reaches a broader audience, the booklet will be available in Spanish, English, and Portuguese. So our goal is clear: to shed a light on human trafficking, demystify the issue, and provide immediate actionable information to empower people to take a stand against it. Now, I'd like to introduce to you some of the key sources we use to inform and support our project. Understanding an issue as complex as human trafficking requires reliable data and deep analysis. Two critical resources that shaped our work were the Greta report on Italy and the Universal Periodic Review recommendations. Let me begin by explaining who Greta is and why their findings are so important. Greta, the group of experts on action against trafficking human beings, was established under the Council of Europe Convention on Action Against Trafficking Human Beings, which came into force in 2008. Their role is to monitor how countries implement the convention, evaluate their anti-trafficking measures, and provide recommendations to improve policies and practices. In their 2023 report on Italy, Greta noted that the country remains both a destination and a transit point for trafficking, with thousands of individuals, primarily women, but also men and transgender individuals, trafficked for forced labor, sexual exploitation, and servitude. Key sectors at risk include agriculture, construction, textiles, domestic work, and hospitalities, industries that often depend on vulnerable migrant labor. While Italy has made efforts such as adopting a national action plan and guidelines against labor exploitation, Greta highlights significant challenges like victim support, legal aid, prolonged trials, migration policies. So Greta urges Italy to improve victim identification in migrant reception centers to prevent re-victimization.
In addition to Greta's findings, we looked at recommendations from the Universal Periodic Review process. During its most recent UPR cycle in 2019, Italy received specific recommendations on combating human trafficking. Countries like Nigeria, Georgia, and the United States emphasized the need to strengthen anti-trafficking laws, enhance victim support, combat labor exploitation, and improve coordination among agencies, governmental agencies, NGOs, and local authorities. These recommendations also urged Italy to ensure its national action plan on trafficking. This plan focuses on years 2022-2025, focuses on prevention, protection, prosecution, and partnership. But its success depends on sustained funding, integrity, collaboration, and commitment to targeting victims with dignity and respect. Now, I'm pleased to pass the floor to Caroline, who will discuss the situation in Spain and provide further insight into our work. Thank you.
Distinguished audience, good evening. Thank you, Lydia, for the introduction. And as we continue this discussion, I would like to highlight that during the previous cycle of the Universal Periodic Review, Spain received 20 recommendations concerning human trafficking and related forms of exploitation. These recommendations specifically focus on protecting vulnerable groups such as women, girls, migrants, and asylum seekers. Key areas of emphasis included the adoption of comprehensive legislative frameworks, improved victim protection, systematic prosecution of traffickers, and training initiatives to enhance the identification and response to trafficking cases. Women and girls were noted as particularly vulnerable to sexual and labor exploitation, while migrants and asylum seekers face heightened risks due to their precarious circumstances, making them the most affected groups. To better understand the scope of human trafficking in Spain, it is essential to note that the country remains primarily a destination and transit hub for victims. Recently, the group of experts on action against trafficking in human beings conducted a review as part of the third evaluation round of the Convention on Action Against Trafficking in Human Beings. And during this evaluation, Spain has shown a strong commitment to addressing this issue and continues to meet the minimum standards for the elimination of trafficking. While this reflects a sustained effort by the government, it also highlights areas that need further attention and improvement. In 2023, there was a significant increase in the investigations within 151 cases of human trafficking examined. Additionally, Spain has advanced victim support systems, with law enforcement identifying more victims and government-funded NGOs expanding their assistance. In the area of policy and legislative reform, Spain implemented its 2021-2022 anti-trafficking National Action Plan and passed the key legislation in 2023 to incentivize the hearing of trafficking survivors. International collaboration has also been a strong point, with Spain engaging in cross-border investigations and partnerships, leading to the identification of victims and the prosecution of traffickers operating across jurisdictions. Comprehensive training programs have further enhanced the ability of officials to identify and assist victims. But however, despite these commendable efforts, significant challenges persist. Formal victim identification remains solely within the purview of the law enforcement, excluding NGOs and other entities. This limitation results in probable underreporting, particularly among vulnerable groups, such as children, undocumented migrants, and asylum seekers. Victims identified by NGOs who choose not to cooperate with law enforcement are excluded from official statistics, creating a gap in the accurate assessment of the problem. Labor trafficking also remains a critical concern. Although the government has increased efforts in this area, the number of the prosecutions and convictions of labor trafficking is disproportionately low, particularly in high-risk sectors such as agriculture and domestic work. Access to justice and compensation for victims is another area where progress is needed. While courts frequently award restitution, few victims actually receive these funds due to the enforcement challenges, because the eligibility criteria for assessing such ID remain restrictive. There are also concerns about the conditional nature of protection mechanisms. Reflection period for victims are often tied to their willingness to participate in criminal proceedings, limiting the access for those unable or unwilling to cooperate. Similarly, legal ID is inconsistently applied, particularly for undocumented migrants and asylum seekers. Child trafficking is another area where improvements are urgently needed. The procedures for identifying child victims, especially unaccompanied minors, are insufficient, and the number of identified child victims remain alarmingly low. Looking ahead, Spain must address these challenges by adopting a more inclusive approach to victim identification, allowing NGOs to formally identify victims and ensure a comprehensive and accurate report. Greater efforts are needed to proactively detect trafficking among asylum seekers, migrants, and workers in high-risk sectors, ensuring that victims are not penalized for unlawful acts committed as a direct result of being trafficked, such as migration offenses. You may have the floor.
In closing, Caroline and I created this project because we often feel that human trafficking remains in the shadows. It is an issue that is rarely discussed in daily life, yet it profoundly impacts so many people across the globe. We wanted to change that by producing a resource that simplifies the complexities of trafficking and offer immediate practical information. The booklet we have developed is our small contribution to raising awareness. By informing more people about this issue, we hope to empower them to recognize the signs of trafficking, understand the system in place to combat trafficking, and take action. Thank you very much for your attention and your time.